Hi everyone, and thank you for joining me today. My name is Ashley Sloat of Aurora Consulting. Today I will be talking about protecting cannabis-related innovations in this new era, in particular patentable innovations. And so let's get started. Again, my name is Ashley Sloat, and so this is a little bit about my background. I have a PhD in the biomedical sciences. I spent a couple of years doing various types of writing or technology transfer work, and then started with Hudak Consulting Group. I moved through the ranks, and then Aurora Consulting bought Hudak Consulting in 2017. Aurora Consulting being my company, and so we continue to offer patent strategy related services. And so if you have any questions for us, or if you'd like to learn more about us, please visit our website at www.aurorapatents.com. So how do you protect cannabis-related innovations? So there are two main mechanisms through which you can protect plants, for example. There is the U.S. Department of Agriculture and the United States Patent and Trademark Office, and I'll talk about each of these in turn, as well as patents outside of the plant sphere. So in the U.S. Department of Agriculture, you can apply for what is called the Plant Variety Protection Certificate, which is under the Plant Variety Protection Act of 1970. And it includes protection for sexually reproduced plants, for example, seeds and tubers. And this is noteworthy because you cannot protect seeds and tubers using a plant patent that is granted from the United States Patent and Trademark Office. However, utility patents can protect seeds and tubers. And so again, the Plant Variety Protection Certificate can be used to protect seeds and tubers. The plant must be new, distinct, uniform, and stable. And its protections are similar to that of patents. They exclude others from selling, offering from sale, reproducing, importing, exporting, or using the varietal to produce a hybrid or different variety. The main difference between a patent and the Plant Variety Protection Certificate is the farmer exception, and that is one in which, with the Plant Variety Protection Certificate, a farmer can buy your seeds under your certificate and plant them, and then harvest the seeds and replant them for subsequent harvests, and they are not infringing your rights under the Plant Variety Protection Act. With a patent, that is not the case. So the patent, the farmer needs to buy the seeds each year for their planting and harvesting. They cannot save the seeds and replant them, and then certainly not sell them. And so that's the main distinct difference. And there's also a little bit of like a research exception under the Plant Variety Protection Certificate. You can buy the seeds and then do research on them to produce a new hybrid, but in order to develop one, you need to license the rights, and under a utility patent, you would also need to license the rights to try to develop a new species or hybrid. And this is valid for 20 years, which is similar to patents, or at least utility and plant patents. So that's the Plant Variety Protection Certificate. As of today, there has not been a Plant Variety Protection Certificate granted on a cannabis strain. And so that remains to be seen, and there is some indication that I've read that they will not grant plant variety protection certificates for cannabis plants, but I have not actually seen that been confirmed by the U.S. Department of Agriculture, so that remains to be seen. So that's just a little bit of note for you on this type of protection. So we've covered the U.S. Department of Agriculture. We'll now talk about the United States Patent and Trademark Office and the different varieties of protection you can achieve under the USPTO. So the USPTO has a couple of patentability requirements, or a few patentability requirements. The item cannot be naturally occurring or an abstract idea. Obviously, this is not required for plant and design patents, but it is required for utility patents, which I'll describe in more detail later. They also have to be novel and non-obvious, and this includes plant and design patents. And so you have to be able to prove that your article of manufacture, your plant, or your design is new or non-obvious over what has been previously shown in the art or previously in the public sphere. So printed newspapers, articles, websites, journal articles, patent publications, anything like that. Your plant design utility patents have to be novel and non-obvious over all of those things prior to your filing date. So what can you protect at the USPTO in the patent system? There are plant patents, design patents, and utility patents, and we'll talk about each of these in turn. A plant patent protects a plant defined by a set of characteristics determined by a single genetic makeup or genotype. So basically you have to create a new plant that has a single genetic makeup or genotype. And so there has been one plant patent issued, and that was at the end of 2016 for a new strain of cannabis. The requirements for plant patents are, again, that it has to be novel and non-obvious. You have to have a fully enabled description and specification. It has to be asexually reproduced and not a tuber. So for the cannabis growers amongst us, the cutting and grafting that you do will be considered asexual reproduction, and so that does qualify under the USPTO plant patent. The most significant issue that this first issued patent came against was they did not have a really fully enabled specification, and so there was significant editing and amending that happened through the course of prosecution to get the patent into a state of good quality. And this is particularly important for plant patents because there are really no claims. I mean, the one claim is basically the Latin name of the plant, so the species and the genus, but that's really all that the claim states, and so you're really heavily relying on what is in the specifications. So that really has to be in extreme detail, and so obviously work with somebody who is a good botanist or agriculturalist or something like that that can really help you delineate all the features of your species very clearly. And this also has a 20-year patent term. So that's the plant patent. The next is design patent. These are kind of going in order of most or least difficult to most difficult, although design and plant, you could argue, are kind of, in terms of difficult level, they're kind of interchangeable. So design patent protects the ornamental appearance of an article of manufacture, not the article itself. And so, again, this is really useful for graphical user interfaces of software applications. And so if you've created a software application for monitoring the growth of your cannabis plants or scheduling care or maybe like a meeting interface for meeting with your patients, if you're a caregiver or anything like that, a graphical user interface design patent may be an option for software. And that's in particular because software is difficult to patent via utility patent, which I'll get into later. You can also use a design patent to protect tools, consumer products, grow or use devices. And so if the different growth or use or tools that you have created have a unique appearance, a design patent may be a good option for you, and it may be used obviously in collaboration with a plant patent or a utility patent. And so a good, healthy patent portfolio will a lot of times have different types of patent to protect different features and or assets of the products that you're trying to sell. And then there is a 14 to 15 year patent term depending on when you filed it. And again, remember that a design patent falls under the novel and non-obvious, just like the plant patent. And so you have to be able to prove that your design is new and non-obvious over any pre-existing designs that were in the public domain prior to your filing date. And then, of course, if you consult a good patent agent or attorney, they can help you at least reduce the likelihood that you're going to come against significant resistance in the patent office. So there's a design patent. And lastly, the utility patent. It protects the way an article of manufacture is used or functions. And so going back to the patentability requirements, I'm coming back to this because, as I mentioned before, plant patents and design patents do not have to overcome the 101 hurdle, or that's 35 USC 101, but they do have to do novel non-obviousness. So I'm bringing this back to show you that utility patents do have to overcome the 101 hurdle, which means they have to be able to prove that whatever they are claiming is not naturally occurring or an abstract idea. And many of you may think that that's a really easy hurdle to overcome, but that's not really the case at this time. In 2012, there was the famous Mayo versus Prometheus Labs, and then in 2014, the Alice versus CLS Bank Supreme Court decisions. And collectively, what those have done to patent law is essentially create this subject matter eligibility test, which a test usually means that, it's there's a clear path to how you can pass it, but that's not the case here. All we have is this framework to work with, and hoping that we can get the right combination of words to overcome this, or to move past this framework. So what does the framework say? So step one is the claim directed to a process, machine, manufacture, or composition of matter. And of course, the very vast majority of the time, this will be a very easy answer. Of course, it's directed to a process, machine, manufacture, composition of matter. I can't even think of any examples of items that aren't. And so, of course, like an abstract idea, but or an algorithm. But if it's not, then it's not eligible, of course. And if it is directed to one of these, then you move on to step 2A. And the question is the claim directed to a law of nature, a natural phenomenon, or an abstract idea. And so in the case of plants, it is could be considered a natural phenomenon by the Patent Office. And I guarantee that you will probably very likely get the Section 101 rejection, because they're going to view that plant as a natural phenomenon. And in terms of software, more often than not, you're probably going to see rejection regarding an abstract idea. And I have some tips for you about how to overcome that, and we'll get to that here shortly. And then if it's not directed to a law of nature, natural phenomenon, or abstract idea, then of course it qualifies as subject matter under 101. But if you can say yes, that it is a law of nature, a natural phenomenon, or an abstract idea, you move to step 2B. And it asks if the claim recites additional elements that amount to significantly more than the judicial exception. And so what does that exactly mean? Well, that's a great question, and not a lot of people know. We're still trying to define the metes and bounds of significantly more, but basically you have to be able to prove that what you are claiming is more than what existed in the art, after your filing date. So if the art had, X, Y, and Z components, you have to be able to prove that, you have more than those X, Y, and Z components after your filing date. And so there's that difference between pre and post filing date. And of course, if you can prove that there's significantly more, you can move on and you've overcome the 101 hurdle. And if you cannot prove that, then your claim is not eligible for patenting. And so what does this practically mean? Well, it means that a lot of things are patentable, but it's a little bit tricky in some areas like software or dealing with natural products. And so for the case of new plant varieties, you can patent new plant varieties using the utility patent. And to date, only one has been granted, and it's a new cannabis variety. They had to overcome relatively significant obstacles to prove that they could overcome the 101 hurdle. Essentially, what they did was purchase the strains that the Patent Office was citing as the prior strains and saying that there was nothing new as compared to these prior strains. And they subjected these strains to similar chemical analysis that they had subjected their own new strain to, and were able to show that the terpene profile was significantly different, and that was dominated by one particular terpene, and that and they did some claim amendments as well. But the biggest thing is that they were able to show that the CBD content was different and the terpene profile was different, and that was by subjecting the cited strains to the same chemicalness that they had directed their own strain to. So that was how that one was granted. And so, and the other noteworthy piece for this patent was that it was granted to Biotech Institute. And why this name is probably familiar to many of you in the cannabis space is that there's been some concern that this Biotech Institute is going to patent every single strain under the sun and prevent anybody from growing, selling, using whatever cannabis. And that's, very likely a stretch. For instance, for this issued patent, it's relatively narrow in that the CBD content, I think, has to at least be 3%, and the terpene profile cannot be dominated by one particular terpene. I can't remember the name of it, but there's definitely some specifics to these claims, and so it's not going to cover all strains out there. And in particular, the Patent Office was citing very particular strains against this patent, and so they had to argue over those strains during prosecution, which creates prosecution estoppel, which essentially means that when or if this patent is ever enforced in a litigation setting, they are going to look through that prosecution history and see that they strongly argued that their strain was different than those other strains. And so if you're growing one of those other strains, you can say, well, they definitely argued that their strain is different and wouldn't be covered by their patent. And basically that prosecution estoppel restricts their claims a little bit based on what they've said, basically the subject matter they disavowed of in prosecution. And so they're not patenting every strain, but I'm sure there will be a decent amount of strains that they do cover and protect, and so you'll have to be wary of that if you are growing it or selling it or anything like that. And again, utility patents can be used to protect seeds, but again, this is different than the plant variety protection certificate. A farmer cannot buy seeds that's protected under utility, plant them, and then collect them and then replant them. And the famous example of this is one in which the Roundup Ready seeds, a farmer had purchased them from Monsanto and he wanted to plant them and then reuse them, but he knew that he couldn't do that. And so he ended up finding a mixture of seeds from another farmer. And basically, so this mixture of seeds had Roundup Ready seeds in them and non-Roundup Ready seeds in it. And so he planted the seeds, sprayed the plants with Roundup, and of course, those that were not resistant died, and those that were resistant with the Roundup Ready gene survived. He basically then took those plants, harvested the seeds, and then planted them. And even going that roundabout way to get those seeds without having to pay for them, which seems like a lot of work when you could have just paid for them, he obviously fell under their patent because, again, you cannot save seeds and then replant them. You have to buy them every year under their patent, unless you kind of come under some agreement with them, but then you're still paying them on a regular basis, probably for some kind of royalty or license. So anyways, long story short, utility patents and plant variety protection certificates are a little bit different in that farmers have different rights under them. Utility patents can also be used to protect devices, systems, methods, and compositions, or even software, like I mentioned. Devices, systems, methods, and compositions, that's pretty straightforward. The biggest one is software or software implemented methods. There you're going to either have to prove that's tied to a specific device. So if you've created a very specific device that runs specific software, then you're probably going to be okay. Or you're going to have to prove that there's something more or that improves the functioning of the computer itself or the internet or something like that. So those are some of the little tidbits I can give you about how to overcome software rejections. But there's also other blog posts I've done that you can look at that helps you determine how to overcome software rejections in this new age of the 101 hurdle. Also, there's a lot of activity in this space already, even in this nascent industry. There's been about somewhere between 1,500 and 7,000 cannabis patent applications or issue patents filed. And this includes one from the U.S. Department of Health and Human Services. Some will argue that it's a little bit of two-faced for the federal government to have cannabis listed as a Schedule I drug, but then for them also to own a patent. But this patent is directed to the non-psycho active effects of cannabis, and so I think they could argue that they are focusing on the other parts of cannabis that are not really their concern for the Schedule I. I'm not trying to condone their activities or anything like that, but just saying that's not as two-faced as it appears. Their patent is directed to those parts of cannabis that are the non-psychoactive agents. And again, this is a 20-year patent term similar to the plant variety protection certificate and the plant patent. So that's a mouthful there on that slide, but that's one of the main avenues and probably your strongest avenue for protection of your new variety or your new devices that you are creating or software. So what about, if you do get a patent, what does this mean? And so many of you may be familiar with this from a dishonorable action or cause an action does not arise. And this basically means that a court will not hear a plaintiff's case if it arises in connection with an illegal act. And so if you are trying to enforce your cannabis patent, a court could argue that they don't want to hear your case because it is arising in connection with an illegal act, i.e. you selling cannabis species or something like that. And this is going to create a lot of issues in the short term because there are a lot of conflicting laws right now. Federally, marijuana is illegal and it has varying degrees of legality in some states, but in a lot of those states, the federal law is still prevailing in terms of court cases. This is evident in a couple of court cases that have dealt with contracts and loans related to cannabis businesses, where a judge in Colorado and a judge in Arizona basically both sided with the non-marijuana related party, or they basically created the null and void contract, basically said that the marijuana contract was null and void because it was related to an illegal act, was against the public policy. So even though it's illegal in some states, the court system is still siding with federal law, which means that cannabis is illegal. And so although you have this patent, that does not necessarily mean that you can practice it, at least under federal law. And that's confusing because patent law is federally regulated, and so you would think that the patent office would not be giving patents for cannabis, but still they are. One of the practice points that we do at Aurora for cannabis-related patents, at least where possible, for devices and methods, we try to claim the methods or devices in a broader way that do not necessarily limit the patentee or the patent owner to just cannabis. So for instance, if you have a new grow method, the grow method in theory could be applied to more than just cannabis. It could be applied to many different types of plant species, legal ones in particular, at least viewed at the federal level. And so we do try to draft things in a broader light so that you have a patent that's enforceable against other plant practices, not just those used in the cannabis industry. And so with enforceability of cannabis patents, the infringer obviously can argue that the patent is invalid because it covers an illegal substance, which has merit. But the patent owner can also argue that federal law gives him the right to stop anybody from practicing his patent invention, which also has merit. And so right now we don't have any cases to go on to understand what the outcome of all this will be, but just, a note for the wary to know your limits and know kind of what you're getting into before you step into it. So there's also some talk of arbitration as a litigation alternative. And so in theory, binding arbitration is enforceable in a court despite the underlying illegality. And so that's one option. And an example of this is there is a Cannabis Dispute Resolution Institute in Colorado, and it's related to marijuana-related arbitration, and I think the first of its kind. So it'll be interesting to see what happens with their arbitration decisions and see if they are enforced in a court of law. And there's also multiple arbitration associations for patent infringement cases, so in theory you should be able to go that route for your cannabis-related patent as well if you're trying to enforce it. But not all hope is lost. There's always some movement in the Senate for changing legislation, at least related to federal and state laws. There, under the Senate bill, Commerce, Justice, Science, and Related Agencies Appropriations Act of 2018, there was an amendment proposed by Patrick Leahy. If many of you may remember him, he was also part of the America Invents Act, which radically changed the patent laws in this country in 2011 and 2012. So Patrick Leahy proposed this amendment. It was approved in the Senate. It basically reduces the ability of the federal level law enforcement agencies to interfere with state laws on medical marijuana use. So it helped kind of further delineate what the federal government can do with medical marijuanas that in states that have legalized it, and hopefully clear up which the federal government or the state has the ultimate say. And so hopefully that will make it all the way through to the president's desk, and we'll see some movement on that. But anyways, I hope I've enlightened you a little bit today about how to protect your cannabis-related innovation. And if you have any questions for us, please do contact us at info@aurorapatents.com, and we can hopefully help you protect your innovations, including those in the cannabis industry, and we'd love to hear from you.